Welcome to the Magisterial Lecture series of the Ateneo de Manila. My the topic of my lecture is the declaration of nullity of marriage in the Catholic Church. Specifically, this concerns the revisions of the Code of Canon Law introduced by Pope Francis in 2015. Now, regarding this declaration of nullity, this is probably the closest that Catholics will ever get to the canon law, the church, the canon law of the church. Okay. I have to say, the theological doctrine remains. What is the theological doctrine? That the sacramental marriage is indissoluble. Remember Mark 10? What God has put together, let no man put asunder. What is modified is the process to determine whether or not God has put this marriage together. I just have to say this. There are three general grounds on which the validity of a marriage can be challenged. One, whether God has put them together. One is a defect of consent. Article 36 of the Family Code of the Philippines was derived from and was based on this. The second is the presence of an impediment. You know, the man is an ordained priest, or the woman is a nun. Now, why they would get together, I don't know, but that would be an impediment. Or if the man was previously married, or they were related, etc., etc. Okay. Those are that is the second ground. The third is a defective canonical form. That is a technicality. What is a technicality? Did the priest who solemnized your marriage, did he have jurisdiction? Was he allowed by the parish priest? Those are the three general grounds. Now, as I said, this is not a matter of the talk. For this technical point in canon law, the petitioner is usually guided by someone from the tribunal. There are guide questions to bring out the relevant points in the case, and the tribunal itself will determine the ground. What I would like to focus on this morning, today, are the 3 points that Pope Francis simplified. One, the competent tribunal. Second, the review or the appeals process. And third, the cost. First, the competent church court. Before August 2015, there are 3 possible bases of jurisdiction. One, the place where the marriage was celebrated. If you got married in Mary the Queen, or in the Manila Cathedral, or in San Agustin, then the competent tribunal would be Manila. Second, the domicile of the respondent, or the place where most of the witnesses will be heard. Now, the usual difficulty before was the parties have lost contact with each other. The petitioner does not know where the respondent lives. And second, not all the church jurisdictions have tribunals. If you were married in Ifugao, Ifugao does not have a church court. If you were married in Leyte, most of the dioceses there do not have tribunal. That complicated the process. Now, the document of Pope Francis entitled Mitis Judex in Latin, in English it means the kind judge. He added a 4th possible competent tribunal, namely the domicile of the petitioner, which simplified it. Okay. Of course, the respondent still needs to be informed, usually through the parents or the children, but this is easier to do now because of social media. This additional provision has made the processing of petitions immensely easier and simpler. The second revision introduced by Pope Francis is the review or the appeals. Before 2015, when the petition for nullity is granted by a lower court, a review was necessary, a review by the appeals court. It's like the death sentence given by a lower court. Whenever somebody is condemned to death, that is reviewed by the Supreme Court. The appeal stage is another long delay, especially in the Philippines, because there is only one appeals court in the Philippines that processes all the decisions granting the nullity of a marriage. Now, after Mitis Judex, anyone who wanted to appeal, the aggrieved party who was not satisfied with the affirmative decision of the first instance is given 40 days to appeal. If no appeal is introduced within the 40 days, then the decision becomes executory and the husband or the wife is let loose and he can now contract another marriage. I said the party or parties because in some cases a restrictive clause is attached to the sentence of nullity. What is a restrictive clause? If the husband was violent, and that was the ground for the annulment, well, obviously, you say the marriage was invalid, but the husband is not allowed to remarry because he will be violent again. But of course, that cannot prevent the husband from marrying, because if you say the marriage was null, then there's no more impediment. Now, why does the court attach a restrictive clause? Is to warn the prospective spouse. Itong mapapangasawa mo is violent. That is why the wife had gotten, or the husband, if it was the wife who was violent, that's why he got an annulment. Third, and possibly the revision that has the most practical consequence is that the Pope decreed that this service should be free of charge. I will repeat. Probably the most practical consequence is that the Pope had decreed that this service should be free of charge. But even before 2015, the practice of tribunals where I had worked is that if the person can afford, he was asked to contribute for the processing fees. If he cannot afford, he was asked to bring a letter from his parish priest attesting to his needfulness. But since 2015, the dioceses who can afford were asked by the Pope to give this service free. In Manila, in the Philippines, many dioceses will be considered third or fourth class municipalities and therefore who are not in a position to do as the Holy Father had asked. But Manila now does not charge, although petitioners who can afford are asked, some cases reminded, hopefully that a donation or a generous donation will help, and most do. I would say, I wish more would do. Now to the fourth part, the conclusion. Perhaps a question that I have not addressed is, how long does the process take? There are certain variables that can lengthen or shorten the processing period. If you submit all the requirements, what are the requirements? Baptismal certificates, the dispensations of their wear, the marriage contract, the names and addresses of witnesses, that will shorten the process. If the witnesses and the respondents especially submit their statements promptly, that will shorten the process. Sometimes, although in fact, in most cases, a personality or an psychological evaluation is required. These evaluations are not created equal. Some are more helpful, others are not as helpful. The tribunal usually suggests experts or psychologists who have proven helpful in the past. As in any other court, Justice Leonen has been threatened with some procedure for not being efficient, or so they say. As in any other court, some judges are able to dispose of their cases more efficiently than others. Not that these judges are indolent or they watch movies or Netflix too much, but for most of us judges, it is a second or a third, or in some cases, even a fourth job. And so it also depends on the judge to whom your case is referred. But in answer to that question, how long? Normally between 12 to 18 months. I was about to say, are there any questions? But I don't think there are. Thank you.